appeal in the matter of AHGR Ltd and Kane-Laverack and
Yes, Mr. Douglas.
I'm here on behalf of the appellant,
Yes.
my own friends, Ms Stacey King's counsel, and Mr Grant here on behalf of the respondents. There are a couple of preliminary matters for us to run through before we get into the appeal proper.
Certainly.
Which I hope that we'll be able to dispatch reasonably swiftly. The first is that there's an application for extension of time for purposes of the respondent's notice. My client has consented to that, and I don't believe we need to address you any further on that unless you think differently. Learned Friend has also submitted a request to rely on the decision relating to the Commission application for the Wood decision about subsequent conduct. You would have seen her email last week.
Yes.
That, of course, is a matter for you, but speaking purely for myself, I don't object to them referring to that decision. So hopefully
Thank you
we
for
can
clarifying that. No problem with
time.
that. No problem with that. No, that's absolutely fine. Thank you.
I'm most grateful. Then to a slightly more contentious matter, which is my application, re the documents that are contained in the unagreed bundle. There are two ways of dealing with that issue. My firm preference would be to simply get on with the appeal and for my learned friend and I to make our submissions and address you on the relevance of the documents contained in the unagreed bundle when we get there. Learned friends say they want you to hear submissions from both of us as to whether you should or shouldn't promote those documents into the supplementary bundle and then make a ruling about that. I would invite you to adopt my suggested course. To be clear, as your ladyship and your lordships may already have seen, these are not new documents or intrinsically controversial documents. They're the two trial witness statements in which the respondents gave evidence describing the work that they do at the unit and also elsewhere, and the transcripts of the oral evidence in which they were asked questions at trial about that. This is all material that was included in the bundle for the first appeal before Mr Justice Meade. So there's nothing new or difficult about the documents themselves. In order to understand why we respectively say that these documents are or aren't relevant, we would need to descend into the substantive arguments, and if we have to deal with that up front, that would take time. It would be easier and better to do that once we set out our stall on the substantive arguments. And I do have a good deal of ground to cover, so I am a bit conscious of the timing question.
Well, just on that, I mean, we have all read extensively into this. In fact, I'm surprised to hear you say that there's a timing issue because we felt that it might be dealt with in the morning. But,
I'm grateful for that indication.
I can assure you that we have done a considerable amount of reading.
Yes, well, I will bear that helpful indication in mind as we go through. Nevertheless, my skeleton argument doesn't purport to be anything like a full exposition of what I would like to urge upon you. But at any rate, we would be hoping not to lose time in relation to having a procedural wrangle about what goes into the bundle. So,
well, should we not waste any more time you telling us why we shouldn't do that, and we'll just have a word about that. Yes, what
with it very briefly. Our preference is that it should be dealt with at the outset. This is essentially a housekeeping matter, but it's not simply a housekeeping matter because the effect of the documents that they're seeking to put in, we say, could be quite important as a matter of principle, and it's desirable that the parties proceed knowing what the parameters of the appeal are. My lords, my lady, the reason we're objecting is essentially twofold, and as set out in the email, which is in the supplemental bundle, which sets out our objections. But essentially it's this. The documents that are permissible in terms of putting into the supplemental bundle need to be relevant to the grounds of appeal. The grounds of appeal are limited to the findings of the judge. There is no reason, therefore, we say, to look beyond the judgment itself. That's the first point. The effect is the second point. If Mr Duckworth is entitled to do so, effectively he's seeking by the back door to supplement, expand and amplify the findings of the judge in relation to his construction of work, which essentially they say means business. which essentially means only commercial, not charitable. So for all of those reasons, we don't want to proceed with an appeal not knowing quite what he sought to extract from the various documents, which we say shouldn't be there in the first place.
Thank you. Yes, Mr. Duckworth, we're going to consider them in ASA, but I would just remind you that that's the position at the moment, so they're not admitted at the moment. I think you're familiar with what's in them, obviously, but we will keep you very tightly to the grounds of appeal, and we are not proposing to make findings of fact. That was done by the judge, and I would remind you this is a second appeal.
Yes, I'm very grateful. In that case, let me...
So very extreme caution with the use you try and persuade us to put them to.
Understood. You will have appreciated that the appeal raises two issues.
Yes.
One is the construction of the planning permission and the user covenant in the lease. And the question is whether the activities carried on by the respondent over the relevant period constitute compliance or breach with the planning permission and the lease. The decision that I'm appealing is, of course, that of Mr. Justice Meade. Having said that, Mr. Justice Meade concluded that His Honour Judge Johns was right for the reasons that he gave. So I will be principally taking aim at the decision of His Honour Judge Johns. The other point to say at the outset is that, of course, although my claim is a claim for relief to which I say my client is entitled under the lease, it is, I think, common ground between my learned friends and I that the term live work unit in the leasehold covenant has to carry the same meaning as it does in the planning permission. And thus, once you have construed the planning permission, that supplies the answer to the meaning of the covenant in the lease. And therefore, I'm going to focus most of my fire, as both judges did below, on the question of what the planning permission means. The interpretation of the planning permission has two parts to it, as you will have appreciated. One is what is the meaning of the oblique stroke in the term live work unit, and the other, what is the meaning of the work component of that term. I'm going to begin with the oblique stroke, and if I can start with something of an overview as to the battle lines in relation to that particular dispute. It is common ground, as both judges found, that there is a linguistic ambiguity in the term live/work unit. It viewed purely as a matter of language, it is capable of meaning live and work, live and or work, or indeed live or work, albeit that neither party champions that third alternative as the correct construction. It is also common ground between my learned friends and I, as a matter of principle, that if the planning permission as a whole, including the documents that it incorporates by reference, supplies a clear answer to the linguistic ambiguity, the reasonable reader of the planning permission would look no further, or perhaps more accurately, would inevitably prefer the meaning suggested by the indications within the four corners of the planning permission to one that might be reached by recourse to extrinsic material. So, putting it shortly, if my learned friends are right that the planning permission and the incorporated planning plans provide a clear answer to what the oblique stroke means, my appeal doesn't get off the ground. But if I get over that first hurdle, and the plans and the permission itself don't supply a clear answer to the meaning of the oblique stroke, again, I understand it to be common ground between my learned friends and I that, in principle at least, material that's extrinsic to the planning permission can play a meaningful role in the construction process. There is no consensus between us as to which bits of extrinsic evidence should play a role, and there is significant disagreement between us as to what conclusions you should draw. Nevertheless, the documents that between us we refer to in the context of extrinsic material are, or the pieces of evidence are fourfold. There is the Supplementary Planning Guidance from 1999. There is the 1999 planning permission for this particular property, one that precedes permission that you're currently concerned with. There is a planning officer's report deferring the substantive decision, the one at tab 9 of the supplementary bundle. And then there is His Honour Judge Johns' factual finding that the kitchen facilities were ultimately constructed in the southern half of the unit, not in the northern half as indicated on the plans that form part of the permission. And I will in due course address you on those four categories of extrinsic evidence in due course. As regards the legal principles, I want to say something very briefly about construction planning permissions. I want to say something, a brief word about supplementary planning guidance and their role in the planning process, and then again only briefly touch upon the concept of live-work planning use. I don't think there is any real daylight between my learned friends and I as to the ordinary principles of construction of planning permissions. Both my learned friend and I have referred you to the paragraph in paragraph 34 of Trump, page 123 of the authorities bundle, which sets out the correct approach, including the approach to extrinsic material, and when extrinsic material might play a decisive role in the construction process. If your ladyship and your lordships have already looked at that, I won't take you back to it.
But you must take us to it if you wish us to write it again.
Well,
we are familiar with it, but we're very happy to look at it again.
No, well, if you're familiar with it, let's take time up over it. What I would like to say is just to remind the court that the question of use of other documents, extrinsic material, is taken up in the UBB decision at 56 and 57. Again, I don't understand there to be any argument between the learned friend and I about that. But one further point that arises out of Trump that is worth drawing the court's attention to, if you have not already looked at it, is what Lord Carnwath says in paragraph 66 on page 132. It would be tempting to assume when one looks at what is said about when one does or doesn't use extrinsic material that there are special rules when it comes to planning permissions. Lord Carnwath makes clear in this paragraph that it's not right to regard the process of interpreting a planning permission as differing materially from that appropriate to other legal documents. It goes on just at G. Any such document, of course, must be interpreted in its particular legal and factual context. One aspect of that context is that the planning permission is a public document which may be relied on by parties unrelated to those originally involved. And then after the parenthetical words, it's also to be borne in mind that planning conditions may be used to support criminal sanctions. Those are good reasons for a relatively cautious approach, for example, in well-established rules limiting categories of documents which may be used in interpreting a planning permission. And then there's a reference to the Shepway case. And so no special rules, ordinary principles of construing contracts and other documents. It's merely a contextual factor that the reasonable reader would have well in mind. This is a public document. It's got to be easily understood by people, not just the original parties, but somebody looking at it 5, 10, 15 or more years after the permission was entered into. And really, that principle is very much on all fours with what Lord Justice Lewison says about how one construes registered leases in Cherry Tree. There is a couple of areas of potential daylight between my learned friend and I. I just want to draw attention to them briefly now and come back to them if I need to. One is that if you look at His Honour Judge Johns' decision in the core bundle at page 264, paragraph 29 at the bottom of the page, paragraph 29 at the very bottom of the page, he says, further, travelling outside the scope of the planning permission can bring criminal consequences, as was recognised by Judge Cook in Bishopsgate. That points to a wider rather than narrow construction. That sentence sounds suspiciously like a broad principle being suggested that where you have two rival interpretations of a planning permission, the risk of criminal sanctions for breaching the planning permission is a reason why the court should prefer or lean towards a broader or more generous interpretation. If that's the right reading, and it's not absolutely clear, that is wrong. The correct role of possibility of criminal sanctions is as Lord Carnworth described in paragraph 66, which is it is a contextual factor that justifies a degree of caution when considering whether to take account of matters that are material that is extrinsic to the planning permission, which somebody 10 years on, a subsequent owner in 10, 15 years' time, might not have access to. That narrower principle is where the risk of criminal sanctions comes in. There is not a sort of public law equivalent to contra proferentum when it comes to construing planning permissions.
How do you read the third sentence of that paragraph? Because I can understand why you say wider rather than narrower, but then the reason given, which he agrees with, is that people need to know when they've done wrong, which would suggest a narrower construction.
Well, I'm not sure that it does, because the point is this, that as a matter of logic, the risk of criminal sanctions doesn't really help when you're choosing between two rival interpretations. One simply has to construe the planning permission, work out which it is, and on either interpretation, whichever one is found to be correct, if you step outside the use authorised by the planning permission, you would potentially, eventually, be subject to criminal sanctions. But that doesn't really help when it comes to choosing between the two rival formulations. And there is, in the higher statements of the relevant principles, nothing in Trump or indeed elsewhere, nothing to support the general contra proferentum sort of principle whereby you should always favour something that is more generous or more lenient to the occupier of the land to which the planning permission relates. Moving on, if I may, the other issue that my learned friend and I disagree about is whether and in what circumstances it would be permissible to have regard to conduct subsequent to the grant of the planning permission, in particular how it is implemented. I'd like to park that, if I may, and deal with it when we come to looking at the kitchen and the significance of the finding that the kitchen facilities were ultimately sited in the southern half of the unit. Moving on to the question of SPGs, I don't think there is really any daylight between my learned friends and I about the statutory scheme. We have provided you in the authorities bundle with the relevant provisions, relevant sections of the Town and Country Planning Act 1990 as it stood as at the time of this planning permission. It is common ground that under section 54A of that act, when an application for planning permission is made to the local planning authority, the local planning authority is obliged to make the decision about whether to grant or refuse consent in accordance with the development plan, unless material considerations indicate otherwise. Now, where does supplementary planning guidance fit into that scheme? Well, the answer, one receives some assistance from the PPG 12, which your ladyship and your lordships will find in the supplementary bundle at page 90. And really it's the first paragraph of, first sentence of paragraph 315, 316 and 317 that I'm most interested in. Firstly, supplementary planning guidance does not form part of the development plan. It can take the form of design guides, or area development work, supplemental to other specific policies in the plan, but it's not the plan itself, and therefore it does not enjoy the same status under section 54A of the 1990 Act, and that's the point that's made in the first sentence of paragraph 316. Nevertheless, as is made clear there, supplementary planning guidance does have a role to play because it could be a material consideration that justifies departing from a development plan. And it has a further role to play at 3.17. An SPG can play a valuable role in supplementing plan policies and proposals. So it is a document, it forms part of the armoury that is available to you in construing the planning permission, and its role in life is not as exalted as the development plan. Nevertheless, it provides a role in supplementing plan policies, and we'll see why that is important in a moment. Live work. The reason why we're all here is that there is no statutory definition of what live work development or live work unit means. No policy or guidance at a national level that tells us about that. There was an ODPM circular in 2005, page 111 of the supplementary bundle, which refers to live work as a mix of residential and business uses, but I accept that I can't plant my flag in that because it postdates the planning permission, so it couldn't be a reason for construing our planning permission.
So we don't need to take that into consideration?
No, I accept.
And it's in the bundle because?
Lady, simply because it's been referred to in a number of the skeleton arguments. But you don't need to construe the planning permission by reference to that document. I accept that. And the net result is that local authorities have been left to chart their own course in terms of what live work development means and how it is to be applied. And there is a report, but I'm not going to take you to it, in the supplementary bundle in which the paths taken by different authorities have been summarised. But suffice to say, they've all gone about it in a different way, and this has been left up to them to do so. So that's live work. May I come on quickly to the question of whether the meaning of live work unit in our planning permission is supplied by the planning permission and the documents that it incorporates by reference. I understand that the court will have looked at the planning permission, and you will have seen that the operative part refers to planning permission for residences, business units, and one live work unit. There is nothing in the text that really helps us as to what live work unit means, but it of course incorporates plans by reference, and chief amongst those is the plan at 404A, which I'm sure you have.
Shall we go back to that?
Yes, I'm grateful. That is at page 109. And there is an enlargement of it at page 2 of my skeleton argument. But here is the plan in toto. And effectively, what Judge Johns says is that this plan, and also Plan 403B, which we'll come on to in a minute, are the documents that supply the clear answer to the linguistic ambiguity created by the oblique stroke. And he makes that clear in paragraph 27 of his judgment at page 264 of the core bundle. He expresses his view that this is live and or work, and says this is principally because of the nature of the premises as shown on the plan forming part of the planning permission. As shown, they're simply not a live-work unit in the sense of a unit designed with residential accommodation in one part and space suiting a range of B1 uses in another part. They're portrayed on the plan as a conventional flat. He's here, of course, talking about the physical characteristics, configuration characteristics of the unit, but his point is also, as one sees from paragraph 31, about the way in which the plan is marked up and labelled.
So, because we've got a photocopy, can I just confirm with you that my understanding of the judgment is that Unit 8 shows the same shading that we get on the key as work live, is that right?
Well, that is, I find it very, I've only ever had this plan to work with myself. I must say, I find it very, very difficult to draw any conclusions about the shading almost anywhere in the building. The only reason why I don't advance any significant opposition to the suggestion that it must be continuous shading is that if you look at the key,
yeah,
the way in which it's set up is it looks as though there is a shading for work/live, and helpfully reversing the normal order of those two things. So I think it's probably right that that is the case.
Well, the judge made that finding.
Yes.
So, I mean, and his finding is the whole of Unit 8 is shaded as work live. Is that right?
Yes, that is his view.
Thank you. Sorry to interrupt.
So what he's saying, he makes 2 points about this plan. Firstly, is a matter of its configuration and physical characteristics. This is just a flat. And secondly, is a matter of the way in which the draftsman has marked it up in terms of the shading of the key. There is no separate designation of a workspace. I want to take those two things in turn and look firstly at the question of physical characteristics. I say that the suggestion that this looks just like a flat, as opposed to a unit which might be used partly or wholly for business purposes, is simply wrong. It's common ground that, with the exception of the bathroom facilities that one sees and the kitchen facilities that one can see shown on that plan, that this is a unit, part of a new build construction in shell condition. The fact that this unit contains those facilities which are appropriate and necessary for living tells us nothing about the debate as to whether the oblique stroke stands for and or, because that would be appropriate whichever of those three alternatives is correct. There is nothing in the physical characteristics of the unit that you're looking at now that would indicate that this property could not be used in whole or in part as an office. Judge Johns stated in paragraph 5 of his judgment that there was some evidence, may not have made a formal finding, but some evidence that that is how the previous occupier of the unit had used this unit. At any rate, in principle, there's no reason why this couldn't be an office or a private tutor's classroom or an artist or photographer's studio or almost anything else. It is useful, I suggest, to compare the equivalent plan for the 1999 planning permission, which is in the supplementary bundle at page 82. I should say at the outset, on arrival at that plan, you will see that there are some manuscript editions in blue. Those are not original. Those are manuscript editions from the respondents expert. He included a copy of this plan as an annex to his report. Likewise, the coloured shading belongs to the respondents expert, but I accept that what that does is accentuate the shading that one can already see from the key showing residential use and B1 area. So although the all overshading is not original, it is accurate in the sense of what it shows. But both judges below agree that this is a live-work unit, motivated, I think, in large part by the differentiation shown in the key and the shading. But if we ignore the way in which the plan is marked up and look at its physical characteristics, there are only very subtle differences between the two units as a matter of their physical characteristics. And I say certainly nothing that would differentiate the two units in terms of their suitability for business use.
Sorry to interrupt, just so that I've got a record of it. What are the subtle physical differences?
There is firstly some indicative furniture, which I don't think makes any great difference at all. There are very slight differences in the bathroom and kitchen facilities, but they are otherwise the same entrance point.
I'm so sorry to interrupt. I haven't got the page number, so I was trying to get the answer.
Page 82.
Thank you so much.
It's 82 and 104, I think.
Thank you so much.
102.
So it's 109 versus 84.
84.
82.
So I beg your pardon.
So the skylight seems to have changed.
The toilet,
doors are different.
the toilets have changed.
Yes.
The toilet, I mean, I'm not sure why we're looking at 82. I have to say, at the moment, I'm struggling to understand what I'm supposed to get for comparison.
Well, only that the unit as shown on 109 is no more or less suitable for business use in terms of its physical characteristics than the one on 82. But that's the only point I wanted to make in relation to that.
Well, I mean, you might say it was more suitable for the lower part, the southern part on 109, is potentially more suitable for business use because it has a toilet which you can access from it directly, as I look at it, which I don't think is the case as it happens on 82. But I'm not sure why I'm getting anything from any of that.
Understood. Let me move on. Turning to the way in which the plans have been marked up, His Honour Judge Johns noted in paragraph 31 of his judgment the absence of separately demarcated residential and B1 space, and he regarded that as a signpost that the and/or construction was correct. But of course, at this stage of the analysis, we are only considering the information that is contained within the four corners of the planning permission, with a view to working out whether it clearly resolves the linguistic ambiguity and whether we do or don't need to consider the extrinsic material in any great detail. And I say the reality is that both judges below have got ahead of themselves and lost sight of the sequence of the analysis, because the notion that a true live-work unit must be one in which one finds separately designated workspace and living space, or indeed one in which one finds a designation that the workspace must be businesses falling within use class B1, those have to be notions that have been extracted from either the supplementary planning guidance, the SPG, or perhaps the 1999 Planning Commission that we've just looked at, or some combination of the two. And I say that is an illegitimate step at the stage in which we are considering whether the answer is to be found in the four corners of the Planning Commission. And as I pointed out in my skeleton argument at paragraph 27 on page 124 of the core bundle, His Honour Judge Johns' analysis, both in relation to physical features, the marking up of plans, is, I say, with great respect, drawing the wrong sort of comparison. That the reasonable reader of the Planning Commission is not asking himself or herself whether the Planning Commission authorises C3 residential use rather than some form of business use. Even on the respondent's alternative and/or construction, these premises are not just a flat. They can be used either partly or even wholly for business purposes as a matter of the Planning Commission construed in that way. So asking yourself whether the unit looks just like a flat or whether it is more suitable for use as a purely residential flat really doesn't assist in the process of determining whether the oblique stroke is a cipher for and/or. And the same point falls to be made about the markings of the plan. Business use is authorised on the and/or construction, so the complaint that the plan doesn't shade or label a designated B1 business area really doesn't help with the and/or debate. Moving on from Plan 404A, there's one other plan that Judge Johns paid attention to, which is the one at 403B, one called 403B at page 104 of the supplementary bundle. And if you keep that plan open, but to remind your ladyship and your lordships what His Honour Judge Johns said about that, he said in paragraph 28, noted that the shading of the plan that we looked at before, 404A, shows the whole area shaded as work-live space, no area which may be used for residential purposes according to the plan. And he says that in the middle of the paragraph, that point, it seems to me, is strengthened by considering other plans forming part of the Planning Commission. They use the oblique in the key on those plans to indicate alternative uses. So Plan 403B included in the key, for example, B8A1 for some units, and shop and warehouse and B1/B8 for others. Not suggested that those designations required all such uses to be made of those units. They plainly indicated alternatives. So what Judge Johns is saying, and I think it is a supporting point, this, but nevertheless he says that what the reasonable reader would note is that elsewhere in the planning plans, an oblique stroke is being used in a consistent way and being used in a way that means and. And I say that's just not right. If one comes back to 404A on page 109 and moves to the very next door unit to Unit 8, namely Unit 9, you find that it is labelled Unit 9 Office oblique stroke B1. Verbal description followed by the oblique stroke and the corresponding use class designation. Office is within B1. So the oblique stroke there signifies equivalence. If anything, it's suggestive that the oblique stroke means and or both. But what it certainly doesn't mean here is and or.
Can you just show me on 104 where the oblique stroke is?
Yes, of course. 104, one encounters it in a number of places. The key place that Judge Johns referred to initially is the key itself. And although it's not the world's greatest reproduction, you can tell from Judge Johns's reading that and I agree with him for what it's worth, shows B8, which is warehouse, / A1 area. And if one travels up the plan, as it were, to Unit 6, top right-hand corner, you find the words shop, ampersand, warehouse. Now that, I say, is the verbal description that mirrors the use class designation referred to in the key. But that, if anything, supports my reading.
But no one referred to the ampersand. It's only the strokes that people are looking at.
Well, Judge Johns, I think, makes reference to both. He says that if you look at the oblique strokes that are used both in the key and in that information in Unit 6, it shows that where the draftsman, creator of this plan, uses an oblique stroke, he or she means and. I say one immediately, by comparing shop and warehouse with the key, which is B8, warehouse / A1, there is support for the view that the oblique stroke in the key is one intending to designate and. But there is, of course, that's not the only oblique stroke one finds. In that formulation in Unit 6, you find that there is then, after the verbal description, a further oblique stroke, and then two use class designations which are themselves separated by an oblique stroke. One of the oddities is that one might expect to find shop and warehouse / A1 B8 for consistency. And it's tempting, I suggest, for the reasonable reader to conclude that B1 is a mistake there and that it should be a reference to A1.
Well, we are going into realms of speculation there.
Well, I'm grateful to your ladyship for that indication, but what I say is that...
what you say is paragraph 28, the judge was in error because when one looks at the plans, he's fallen into error because it's not actually consistent for him
Yes.
to say that on each occasion oblique is used, it's in the context of and or.
That's quite right. If one can draw anything, it's support for my and reading, but myself, I don't suggest that we go down this road. It's not support for and or. So I'm putting all of that together.
Yes.
Neither the plan 404A nor the plan 403B provides a clear and unequivocal answer to the question posed by the oblique stroke, and the linguistic ambiguity within the four corners of the planning permission remains even after one has factored those plans in. And the judges were quite wrong to conclude that these plans supplied a clear and or answer. That enables one to opens the door to proper reliance on extrinsic material. And may I just take you quickly through the documents that are relevant, potentially relevant, as extrinsic evidence in the construction process. I'm going to start with the SPG.
Are you going to at some point address us on the comment that's made and referred to by His Honour Judge Johns at paragraph 18 of his judgment while we're looking at these plans?
The deferral officer's comment that this doesn't look like a...
Yeah.
Yes, I am, my lord. If I may, I'd like to deal with the SPG first, but if you would like me to deal with that now, then so be it, I will.
Well, there's somebody, presumably with some degree of expertise, looking at this plan, saying that looks like a flat to me.
Well, yes.
You made a submission about what a reasonable person looking at this plan might think. Whereas we do have somebody who's presumably not only reasonable, but actually somebody who's used to looking at plans, who says this is a flat.
Let me take you to that. That's obviously a matter that your lordship has considered.
Well, since we're looking at the plans, I thought it might be convenient.
But by all means, let me take you to that first. But then I want to come back to the SPG, which is the other bit of it, significant bit of extrinsic material. The report that you're referring to, my lord, is the one in the supplementary bundle at page 95. Yeah. And it's the one, it's dated 13th of February 2001, so it's a couple of weeks before the planning permission is granted. And all that this decision is, all that the report does, is to defer the decision, to kick the can down the road. But there is nevertheless the observation that your lordship has identified and that Judge Johns referred to. Now, what I say, one gets from reading the manuscript notes at the bottom, is that complaint is being made.
Is this a public document, publicly available document?
I don't think either of us can say definitively that it is or it isn't. It is part of the. It is a delegated report from the local planning authority. The extent to which it is publicly available is not something that certainly I can say definitively one way or another.
If I may, our position is it's part of the suite of documents that form the proposal for the planning. You look at the reference number, it's exactly the same reference number, or reg number rather, for the planning permission. So it forms part of the suite of documents that are relevant to this particular application and grant.
I don't disagree about relevance. I think my Lord Snowden's, or Justice Snowden's question was about whether it is publicly available, the document. And I'm not sure. I can't say definitively one way or the other whether this would form part of the material that the public can obtain access to. But it might be. If it is, and if it is a document to be taken into account at all, and but for my part, I'm not sure that one can say that it is. What I say you should take from the notes that appear at the bottom is that the complaint is being made that Plan 403A, unlike the previous 99 permission that was granted, does not differentiate between the living area and the workspace in the manner contemplated by the SPG. I don't say that it is a comment about
delineation. It simply says it bears no similarity to a genuine live-work business unit. Clear and blatant attempt to bypass the affordable housing requirement.
Yes, that's right.
It doesn't say anything about delineation.
Well, what I say
Where do you get that
is that you should. That's what you should take from it, because if you compare the 1999 plan, which was approved by the London Borough of Southwark, that is the difference. We looked at whether there is any real difference in terms of the physical characteristics, and the reality is that there are none, or at least none that make any great difference in this context. What I suggest one should take from this is that it is a complaint that there is no separation of the workspace and the residential space, and no designation of the B1 planning use, as the SPG would says ought ordinarily to be present.
But what this is saying is, look, this is an application for 15 residential flats. I've inserted the word residential because that's what it means. One of them has been designated as a live-work flat in order to avoid having to stump up for avoidable housing. Message to council: if you grant the planning permission, this is going to be a residential flat. It's not a real live-work unit.
Well, I'm not sure that
I don't think that is what one should. It's a blatant attempt to bypass the affordable housing requirement.
Yes, but what can one take from that? What can the reasonable reader take from that? Because one would expect...
You take it that this is the 15th flat, residential flat, in the development.
This is the flat that would tip it into there being a requirement for affordable housing. So it's like the duck. It's like a flat. It is a flat, but they're calling it something different to avoid the affordable housing.
Well,
How I read that.
Well, let me endeavour to persuade your ladyship
Do.
otherwise. I say the reasonable reader would be in some difficulty as to what one takes from this, because what it's suggesting is, I suggest, that this is not a live-work unit in the sense contemplated by the SPG, and the natural conclusion, if that objection were seen through, is that the permission should not be granted. Because there is, because if that objection is true, then it's not a live-work flat, and one would expect to find that either it was refused or that the permission said that this is a planning permission for 15 flats. If that is what it is, and this officer is suggesting, well, let's call a spade or a duck a duck. But what happens is that the planning permission is granted, and one does find a planning permission for a live/work unit. And I say there's plenty for both sides to work with, as it were, albeit in a slightly speculative fashion in this document, because what one can also see from this is the planning officer plainly doesn't recognise the planning concept for which my learned friends contend, which is a live-work unit, which is one in which one can live and or work.
That means you can live. It means you don't have to work.
I entirely appreciate that, but there is no sense that comes out of the remarks made in this report that this one can grant permission for this, and it's just a permission for a live and or work unit, and that's okay. That's a planning use that we recognise, that we adopt in the planning permissions. I say that the remarks made here are as hostile to my learned friends and or construction because as it is to mine. And I come back to the point that the criticism that I levelled at His Honour Judge Johns. This is what we are not considering is whether this permission created simply a C3 flat. They did grant permission for a live-work unit, and as I say, there is absolutely no sense that a live and or work unit is something that the planning officer recognised or thought could be the subject of a legitimate planning permission. Ultimately, the planning permission was granted, and on any view, there is something missing in the picture here. One feels like there must have been further discussions, further decisions made, consideration brought to bear as to whether they should refuse this permission, grant permission as a permission for 15 flats rather than 14, or grant permission for a live/work unit. We just don't really have the information that shows the thinking process that leads from this objection to the grant of a planning permission for one live/work unit. And even if this document is a document which is publicly available and which would be amongst the suite of documents that would be sure that an owner in 10 years' time would have access to, I say it doesn't provide any clear indication, and that it's really a very question-begging and faintly mysterious document, and it would be quite wrong for the court to rest the ultimate determination of the meaning of the live-work planning permission on that document. But far better, if I may, my lord, come back to the SPG, because the SPG, which your ladyship and your lordship finds on page 73, is a document that was produced by the London Borough of Southwark itself about live-work development. And one can see that although this document is produced in February 1999, when we get into the detail, one can see that there had already been live-work planning permissions granted even before the advent of this document.
Can I just ask one question before you get into the detail of that? Having looked at that planning officer's note, the next document is the grant of planning permission. Was that done by the delegated decision making as well? Because it's not awfully clear from the letter.
It's not apparent.
No. Okay.
My learned friends say in their skeleton argument that it was, and
I saw that, and they may well be right. It's just do we know where that comes from?
I don't.
And did the judge make a finding? I don't think it much turns on it. Okay.
No, he didn't.
So we have that comment, and then the next thing chronologically that we know is the grant of planning permission.
Correct.
Yeah. Thank you. Sorry to interrupt.
This is, as His Honour Judge Johns found, an SPG produced by the local planning authority itself. There was some resistance to the notion as to whether this was an SPG, but His Honour Judge Johns has found that it was. There's no challenge to that. So, faced with a live-work planning permission that is ambiguous on its face, I say the reasonable reader would regard this as an obviously useful tool, the obvious tool, to resolve the linguistic ambiguity in live-work. Your Ladyship and your Lordships have read this, so if I may, at a canter pace, draw attention to the provisions which I say you should take account of and what one gets from it before I look at the way the judges below used this.
Certainly, that would be very helpful.
1.1 is...
Sorry, I've missed the page, sorry.
I beg your pardon, my lord, it's 73 in the supplementary bundle.
Sorry.
And 1.1 tells you immediately that this is aimed at developers, provides advice on future live-work applications. 1.2 provides what I say is effectively a definition of live-work development. And that definition in the first sentence is clearly consistent with the notion of live and work use. What remains of 1.1 and 1.3 set out the planning purposes that are said to underpin live-work development. And 1.4 explains that the SPG deals with the background to live-work development, identifies the specific planning conditions that are likely to be attached. Notice the are likely to be attached to any approval of live-work developments. Final sentence, assessing proposals for live-work development in Bermondsey Street. The first consideration will be their acceptability against relevant planning policies. And section 2 deals with those planning policies, but this is important context because Bermondsey Street is in an employment area and it is subject to the various policies that are referred to in the subparagraphs 2.1.1, the policy of supporting employment generating activities and reusing vacant buildings. 2.1.2, because it's in an employment area and sites identified under B1.2, planning permission will normally only be granted for proposals where the proposed use falls within Class B. So that is the policy, development plan policy backdrop from which this SPG springs. And in 2.3, something goes a little awry in the enumeration over the page. We have reference to planning policy guidance number 1, which applies to all local planning authorities. And one sees that mixed-use development is one of the main objectives of the planning system. And then in 3 under the heading mixed-use development, one sees that the Bermondsey Street Action Plan, sadly we don't have that document available to us, mirrors the PPG1 in encouraging mixed-use developments. And Roman numeral 5 is useful. It's one of the reasons why mixed-use developments are promoted is to provide reduced cost accommodation in the form of live-work units for small...
Sorry, where are you now?
I beg your pardon, Roman numeral 5 under 3.2.
Oh, thank you.
Reduced cost accommodation in the form of live-work units. That's the first time we see our live-work unit deployed in the SPG for small businesses without compromising the employment status of the area. 3.3 is important because it explains what follows. There's reference to a survey of planning permissions granted before the SPG to see how the units were used in practice and whether they were being used for what would be regarded as authentic live-work use. And it is apparent from what follows that there are 2 problems with the way in which existing live-work planning units are being used. One is the one that one finds in 3.3.2, insufficient business use, mere homeworking of the kind that is permitted under a C3 permission. And 3.3.4, which is the difficulty in policing and proving breach of the live-work requirement if the planning permission doesn't require separation of the residential and business elements. I say that is the practical difficulty for the enforcing authority to tell one way or another whether this unit is being used properly for business purposes as well, or whether this is really just being used as a flat. And that is an abuse of the concept of live-work development, and one sees another hint of that in 3.3.5. Small live-work units may be defined as domestic premises for council tax rather than subject to business rates. This fact may encourage abuse of the lawful use of approved live-work units. So the fact that you are being charged council tax may cause owners of property subject to an existing live-work unit to think, that's fine, I can use this just as a flat. And what follows in section 3 and 4, I say, are measures that the London Borough of Southwark identified, which are ways in which they might enable themselves to better snuff out inauthentic live-work use in planning permissions granted in the future. And the 2 ways in which one might do that is by incorporation of the design specifications in section 4 and by means of the imposition of the conditions that you find in section 5.
So did they do any of those in relation to this unit?
No. No, I'll come on to that in just a...
which we deduce what?
Well, what I say the conditions achieve they are bolt-on restrictions to a live and or work planning use, signified by the term live work, which further restrict how the unit is to be used. In particular, they prescribe where the business part of the permission must be carried on, and they limit it where they are imposed. I'll bring you back to paragraph 1.4 that makes it clear that they won't necessarily be imposed, but where they are, they restrict the business element to businesses falling within use class B1. And the other aspect of...
So they didn't, for example, do what 4.2.2 suggested?
That's quite right, but nor, Lord, did they do that in the 1999 permission. In the 1999 permission, for example, if your Lordship, before turning to it, looks at 4.2.5, one of the design requirements is that there should be double doors, minimum of 2 millimeters width, high ceilings and good lifts, goods lifts on good lift. If you look at the 1999 permission, single door, no goods lift. Moreover, if you travel up to the...
Sorry, I'm behind you.
I beg your pardon. If you look at the 99 permission at page 82, starting with the plan, there isn't a double door.
Well, hang on, sorry. 4.2.2. I mean, we don't know, do we, whether there was a separate delineation.
Well, I think my reading of 4.2.5 is that the design specifications that...
No, 4.2, I'm looking at 4.2.2.
Oh no, that bit I agree is the 1999 consent is compliant as a matter of 4.2.2, but I was looking at the 99 permission.
So somebody looking at these two things together in 1999 would have said, okay, this is a unit where where one bit has been designated for work use and the other one designated for residential use. Yes?
Yes.
And they wouldn't find that in the permission we're looking at.
I agree.
So what deduction would you draw from that?
Well, can I, just before leaving the 1999 planning permission, can I just draw attention to the fact that it too does not comply with sections 4 and section 5 of the SPG, because at 4.2.5, one of the design specifications that live work units are supposed to have, or will generally have, as I say is the better way of reading this, is double doors and goods lifts. And the plan at 82 makes it clear that neither of those specifications is included.
I get that neither of them has double doors and goods lift. Okay.
So
Can we go back to the delineation which I was asking you about? So in 1999, there is a separate delineation, I think,
yes,
of business or work and residential use.
Yes.
And there isn't in the plans that we're looking at.
Yes.
So what deduction might somebody make as to whether the council was granting permission, on what basis the council was granting permission, as between those two different plans?
Yes, but this is the point that the judges below took, and I say that it is wrong to assume from the absence of compliance with the design specifications and the failure to impose section 5 conditions that one then defaults to the notion that this is a planning permission that permits living and or working, and therefore a planning permission that could be used for purely residential purposes. That is not the only way of rationalising the lack of conformity between this planning permission and the terms of the SPG. An alternative explanation within the realms of an alternative possible explanation is that the term live-work unit means, as the SPG suggests, top to bottom, living and working. So that this is a live and work planning permission to which, in respect of which, the local planning authority has exercised its residual discretion, which undoubtedly exists, not to prescribe the location of the business element, and in effect to leave that up to the occupier to decide, and in respect of which it is likewise elected not to be prescriptive about the business that is carried on, and therefore they are not shackled to use Class B1 businesses only. They can carry out other forms of business. And I say that that interpretation is an alternative which has not been properly taken into account by the judges below, and which I would commend to you. And it's right for a number of reasons. Firstly, the SPG is, of course, as its name suggests, guidance, not to be treated like statute. And as we looked at in PPG 12, it is something that would inform the local authority, but not bind the local authority to adhere to its terms in the way that a development plan would do. There are, as I've indicated, textual indications, including in paragraph 1.4, that the conditions in section 5 are usual but not invariable requirements. And that is, of course, itself consistent with what one found in section 2, which is that the development plan policy against which the SPG falls to be judged is one in which normally encourages planning permissions granted limited to B1 use. But again, there's no suggestion that that is the invariable practice. And in my submission, the reasonable reader would regard that that alternative reading as preferable. It is consistent with the 1999 permission, which, as we've seen, doesn't adhere to the...
But we're not dealing with the 1999 permission.
Yes, but that is another extrinsic document that the reasonable reader in trying to...
You seem to be basing virtually all your case on the 1999
No, I'm not, milady, but I would say that it is a factor that, looking at that decision, none of the conditions that were required in section 5 were imposed, and the design specs weren't included. But it goes beyond that. I very much do not base all of my case on the 1999 permission. I say that is the better way of reading it, because otherwise, where every aspect of the SPG is suggestive that the answer to the question, what does live, work, unit, as used and applied by the London Borough of Southwark mean, is suggestive that the answer is live and work. So that my interpretation, which is that this is a less restrictive live and or work planning permission, sits okay alongside the SPG. By contrast, there is nothing at all in the SPG to suggest that the London Borough of Southwark recognises or applies the concept of a live and or work planning permission. Indeed, every thing that is said within that document is hostile to it, that the main thrust of the SPG is that purely residential use is not authentic live-work use, and that there are measures which generally should be taken to ensure that properties cannot be used as just a flat.
Yeah, but so 5.1, which you've been drawing attention to, says that the following conditions should be attached to the planning permission. So if you don't attach those conditions, what is the normal reader to assume? Why can't he just assume the council actually just doesn't give the stuff?
Well,
for this particular unit, I mean, one understands your general proposition, but can I just ask this, because you accept we're entitled to look at that sort of handwritten note, and a reasonable reader might say, as you say, live and work means live and work. The council have been frustrated by the lack of development of this particular unit. They consider this to be an obvious ploy. All those conditions which would mean that it was live and work, they don't bother to apply, and they sanction it, having described it in terms as an obvious ploy.
Yes, but where I say that goes wrong is to make the leap from the absence of a condition that says you can only carry on business in this half of the unit, and an absence of a condition that says you can't carry on any business, it has to be a B1 business, straight away to the position where you end up that, well, this must be a planning permission which authorises live and or work and therefore can be used just as a flat. That's not the only alternative way, that's not the only way of rationalising it. The alternative way of rationalising it is that it's a live and work planning permission, which is what is suggested by the SPG, but it's a less restrictive one.
I'm sorry, but why is it suggested by the SPG when it doesn't fulfil any of virtually none of the design or conditions?
Well, those conditions, as I say, are bolt-on restrictions.
I know, but you're saying it's, you look at the SPG and this is obviously live and work.
Yes.
And I'm saying, how do I take that from this document, even if it's right to refer to it, when almost entirely none of the design or planning permissions are to be found in this planning permission?
Well,
that, as my lord says, in relation to this particular property.
Well, what you take from the SPG is that live-work development is, as it is defined in 1.2, and I've taken you to the provisions which are all supportive of the notion that that term, live-work unit, is one which is understood as meaning live and work. And there is no conceptual problem, I say, particularly when one takes into account the fact that SPGs are guidance, not binding, with the local planning authority exercising its discretion in a given case to grant a planning permission which is live and work, but which does not contain the bolt-on restrictions in condition 5. And there's another reason.
Well, or design in condition 4. I mean, or design in
Yes.
paragraph 4, which are called requirements.
I entirely accept that. I entirely accept that. But look at it the other way. I mean, everything in this document suggests that the idea that a live-work unit, a property that is subject to a live-work planning permission, could be used as just a flat, is inauthentic use. It is something that needs to be snuffed out and prevented. That is not what they mean by live-work.
Well, if they don't want it to be used in that way, the onus is on them to snuff it out.
Well,
And they didn't.
Well, my lord, I do say that that is tending to default towards the live and or work permission in circumstances where the less restrictive live and work permission is more in keeping with the SPG. And there is another point which I say is significant and would operate on the mind of the reasonable reader, and that is this. If that is right, then the term live-work unit is not a sui generis planning use at all. It is an umbrella term which, depending a bit on what one takes out of the plans and what one takes out of the conditions, could apply to any one of 3 importantly different planning uses: live and work, live and or work, live or work. And that would be a very surprising result for the reasonable reader to find that there is in effect no fixed or single meaning to the term live-work unit, and that even though applications for one live-work unit are made and permissions are granted, so that the reasonable reader has to stare into the plans, as we have done on 403A, and tease out inferences as to which of those 3 things is to be permitted. Everything else, when one has a permission for a dwelling or a shop or a hostel, those are all single concepts. They're not umbrella terms that embrace a collection of different planning uses. And I say that the reasonable reader would expect the term live-work unit to have one meaning.
I thought, just put that back into context, would you, to one of your earlier submissions, where you said all over the country, different authorities regard live work completely differently, apply it in a different way.
Yes,
so
so-
is that not slightly against
within the
this?
London Borough of Southwark, I beg your pardon, my lady. I wasn't trying to suggest that up and down the country. No, that is. But here we're dealing with principalities in planning terms, and what the reasonable reader is asking himself or herself is what is meant by live work unit in planning permissions granted by the London Borough
All
of
right, so
Southwark.
you're saying that in planning terms, each principality, as you call them,
Yes.
must have a obvious and consistent use or understandable use of live work, even if in the broader planning spectrum across the country, there's loads of different meanings, different interpretations.
Yes, but I don't think there's any problem with that at all, because each of the, and you can see from the 2006 report, each principality produces its own development plan, SPG, or both, and you simply apply that. You don't need to worry about whether the London Borough of Brent is going about it in the same way, and anyone looking at the planning permission granted by the London Borough of Southwark would look at this document, and that would inform how you construe it. But I do say that the reasonable reader would expect planning permissions granted by the London Borough of Southwark for one or more live-work units, we'd expect that term to have a single and consistent meaning, not to be a basket into which various, quite importantly different, planning uses are put, leaving it for the reasonable reader, and ultimately, in due course, successive owners, 5, 10, 20 years after the planning permission, to try and tease out which of the three alternatives was intended.
Can I just go back to 3.3.2 and 3.3.4, which you took us to?
Yes.
3.3.2, as I read it, highlights that, in fact, the majority of the live-work units surveyed, so in other words, there are units which have that designation, are being used for single-purpose operations such as writing, drawing and photography, which don't create employment and which could take place within a dwelling house without the need for planning permission. And that's referred to as domestic scale activity.
Yes.
So in other words, that's somebody who's living there and using effectively their home for writing, drawing and photography. That's what it's identifying. Yes?
Yes.
And then 3.3.4, conditions which do not refer to a defined area of working floor space appear to allow single-person operations to operate legitimately, as it's difficult to demonstrate on site the balance between working and living space within a unit. Isn't that saying that if you don't impose conditions defining the area of working floor space, it is legitimate for somebody to use the property as a domestic space in which they do other forms of activity?
My Lord, I would respectfully part company with you there. If you look at the heading of that paragraph, it's enforceability of conditions to control usage. What is meant by that is this is looking at the difficulty in practice that the local planning authority encounters in seeking to enforce authentic use of the live-work planning permission.
So if you want to have, as you put it, authentic use of live work, you've got to impose a condition referring to a defined area of working floor space. And if you don't, you must understand, reader of this document, that you won't be able to prohibit, in other words, it will be legitimate for somebody to operate as a domestic unit.
No, my Lord, I think...
Because you can't, because you've created something that you can't enforce, amongst other things, with criminal sanctions.
Well, I'll come to criminal sanctions a little bit later, but what it's saying, I say, your Lordship may read it differently, but let me have a go at persuading you otherwise, is it is recognising, what it's saying to the reader is, if you don't, it's really saying to itself, actually, if you don't impose conditions of these kind, in particular separating out the business and residential space, when you come to stand in the flat or the unit and decide, is this property being used as just a flat, which is not within the spirit per 3.2 of the SPG, and not authentic use of the units per 5.2, you're going to have a hell of a time trying to prove establishing that, because you're not going to be you may end up in the position where the working activities and the residential activities are mixed, not clearly shown, and it's difficult to police. Although that's not within the spirit, that's not authentic use, if you don't require them to separate it, then that's going to be hard for the local planning authority to establish.
On that explanation, what meaning do you give to the words appear to allow single-person operations to operate legitimately?
Well, what I say...
What does legitimate mean?
What you should read from that, with apparent legitimacy.
Oh.
I say if you read the document as a whole, it is the whole of this document is saying we need to ensure that people don't end up using these premises as just flats, because you're not going to create employment, you're not going to reduce transport.
And if you want to achieve that end, which is entirely legitimate, you've got to impose some conditions, of which this is the most obvious one, and it's the one that's singularly missing from these plans as approved.
Well, I say if you want to achieve those ends and have a smooth path to effective enforcement, you include these conditions so there then can't be any argument, or at least much less scope for argument.
Especially when you've had an officer telling you on his interim report, deferral report, that this looks like a flat to me.
Well, I agree that he is saying that there is no separation of the two, which the SPG requires, and you would need good reason, I suspect, to persuade the local authority not to include those conditions. But one thing that you must recognise in assessing Section 3 is that there were already live-work planning permissions, and they seemingly didn't have conditions that required separation of workspace and also use of B1 businesses. And what this is really saying is it's very hard to root out the inauthentic use in those circumstances. So from now on, we should generally include these conditions that will make our lives...
Like they did in 1999, but not in...
Well, actually, they didn't in 1999. I appreciate that my submissions in relation to the 1999 permission haven't found favour so far, but they didn't include the condition. I accept that they achieved something similar by means of the plan. But actually, even then, it's not... What the condition does, if you look at 5.1, is it does more than just separation, achieve separation. It also requires, if you look at the second bullet point, Roman numeral 2, that the residential occupation should be in association with the work part. In other words, you can't have Mr. X carrying on a business in one part of the unit and unrelated Mrs. Y carrying...
Subletting the residential bit and then turning up to work next door. Yeah, no, I understand
That's what they're getting at. But that is something which should be, according to this, in a live-work planning permission. But it notably wasn't. It's not present anywhere, either in the plan or in any conditions imposed on the 1999 permission. And I do say that shows that one mustn't read this as statute from which there could be no departures, and that opens the door, it seems to me, to my submission, which is that this is a less restrictive live and work permission.
But I don't think anybody's saying really it's a statute from which there are no departures. It's somebody looking at the plans and the permission against the background of this. I think the argument against you is that if it was expected to prevent single-person operations of the domestic type referred to in 3.3.2, you would expect to see something to prohibit it, make the prohibition easier to enforce. But you see none of that.
Well, it isn't there, but as I say, it seems to me that if you look at it this way, if what is remarkable, I say, is that there is no guidance in this document or anywhere else dealing with a live-work unit construed in the live and or work fashion.
I think what Lord Justice Snowden, if I'm not mistaken, is saying is we've got the planning officer who says this is a flat. This is a flat. It looks like a flat. I'm deferring. That's what it looks like, he says. So then it goes on, and this guidance, you say, gives you the smooth passage to sort out the difficulties that come with a single person operating their photography or their whatever. And so they go to the guidance, which is there and available for their use when granting this planning permission that we're concerned with. Mm-hmm. And they highlight the danger there at 3.3.4. That's the danger. If you don't do it, the reality is it's going to appear to allow the single person to operate legitimately. That's available, and they still don't do anything.
Well,
so.
Lady, it could be, it'd be perfectly legitimate for the planning authority to wish to grant permission on this occasion for a live-work unit that requires both, as all other live-work units do, but which is not prescriptive about the type of business that you can carry on, or as to whether you carry it on in one part of the unit or the other.
But they'd have to be aware, because they would be familiar with this document, that the consequences of doing that would be appearing to give legitimacy to...
Well, not legitimacy,
word
but it
used.
would make it harder to enforce. But if that's what you wanted to achieve, a less restrictive live and work permission, I say you would do exactly as the local authority has done here. You grant permission for one live-work unit, and you don't attach those conditions.
Can I just ask, before you leave this document, one thing? If you're right, I think your argument is that live and work means, live/work means live and work. You take that from this guidance.
Yes.
One other way of reading this guidance is that is the intended outcome. Here's how you can achieve it. And if you don't, you're not going to get live and work. You might get, as we have already got, lots of people just living.
Well,
can I just get your answer to that proposition, if that's all right?
well, I say that if you read the guidance generally as to what live work is in section 1, what it is intended to promote, the abuses, one can see that quite clearly, they use the term abuse in 3.3.5 of existing live-work planning permissions. It is clearly, in my submission, not the case that this document evidences a willingness on the part of the London Borough of Southwark to acknowledge and permit a live-work use, granting a live-work planning permission, which enables the user to simply use it as a flat. That simply can't be made to fit with anything that one finds in this document. I take my Lord Justice Snowden's point about 3, but I say that if you read that in the round, that is a point about ensuring more efficient and straightforward enforcement, rather than suggesting that there is a legitimate planning use, which is live and or work, which can be just a flat. That runs contrary to the employment policy that is in the development plan, that is something the local authority has to take into account. The notion that that the business use would simply be optional is not consistent with, indeed is contrary to the policy background. It's contrary to how it's defined at the start, for the planning purposes, and in section 3 to the initiative that is the main objective of the government's approach to the planning system, is to produce mixed use development. And what my Lord Justice Snowden has in mind is something which is effectively not, or not in any shape or form the same sort of mixed-use development is being contemplated in the SPG. In my
But this warehouse there were commercial units separately from the residential unit, so it was mixed use in that sense.
I take that point, yes.
And I mean, because you might think a local planning authority just wants to get on with this and get the benefit of those offices and those units and live with the fact that they haven't done what they would intend to do for the unit we're considering.
Well, for the reasons I've already given, I would not accept that proposition. I say that if they really were saying giving up on this unit as being effectively just a flat, they would have granted permission for a flat, and that having granted permission for a live/work unit, everything in this document is indicative that the oblique stroke means and. It would be strange and problematic from the point of view of the smooth functioning of the planning system for live/work to be an umbrella term that just embraces all sorts of different things depending on the circumstances of any given case.
But if they had done as you suggest there, wouldn't that have taken them straight into the difficulties about affordable housing? I mean, they couldn't, could they, give the planning permission just as a flat?
Well, something a bit strange has gone on here, if you have regard to the planning officer's report, because something different from what's happened is what one would expect to find. If the planning officer was saying that this is really just a flat and that they ought to pay affordable housing, then that's what one would expect to happen. Alternatively, you might find them to say, well, we are going to grant you permission, but it is for a live-work unit. And then you end up with a live and work situation. It's very difficult to explain what has gone on. As I say, I think...
Or they just turn a blind eye to what is portrayed on the plans as a flat to any person reading it, including the housing officer. But if they were to take steps to impose the conditions, if they were to take steps and call a flat, they would have to insist that the developer provides affordable housing, which might have then consequences for whether the development went ahead at all.
Well, I would urge your lordship against the notion that effectively what the local authority has done is to just turn a blind eye.
Well, you said something odd had gone on. I'm just following up, trying to understand what the odd thing that you say has gone on is.
Something has gone on that's odd between the date of that planning officer's report and the moment at which permission is granted for a live-work unit. That the decision was deferred to decide what to do about that, and a planning permission was granted, not for a flat, and I would urge you against the conclusion that the local authority has granted permission for X, knowing that it's really Y, turning a blind eye. I suggest that what you should take from that, if you take into account the planning officer's report, I think you need to take some care about that, is that the decision has been made to grant planning permission, but they are being held to a live-work unit rather than a pure residential flat, albeit they had an indulgence in that the majority of applications would have a requirement imposed upon them that they have business in one part and residential in another, and the majority of applications would have a condition imposed restricting the business to B1. That's how I invite.
But do you accept that between the planning officer's note and the granting of planning permission, nothing was done, if you like, to reassure the planning officer or to give anything by way of the design or the conditions which would have changed his view of this is simply a flat?
Well, my lady, I would urge a degree of caution, because we are just speculating. The natural conclusion of the objection, the manuscript note at the bottom of the deferral report, is that this application should not be permitted.
Well, deferred, not permitted. Not
Well,
submitted.
deferred because further thought needs to be given to it, because as it stands, it looks like this may be a attempt to get out of the affordable housing requirement. We just don't know what has gone on, what thought process has gone on, which has led from the position as at 2 weeks before the planning, as at the 13th of February, to the point at which planning permission is granted. I think it's very difficult to unpick that, and I think it's potentially dangerous path to go down. And as I say, for my part, I'll hear my learned friend in a moment. It's not even clear that this is a publicly available document in the first place, but what it is a mysterious document in terms of understanding the thinking process that lies behind the decision to grant planning permission for 14 residential units and 1 live-work unit.
Thank you.
I'm going to move on just so that I don't run short of time to deal with the last remaining piece of extrinsic evidence, and that is the question of the implementation post the grant of the 2001 planning permission. There is a reference in paragraph 36.2 of the judgment in the core bundle at page 266 to the decision of Mr. Justice Lindblom, as he then was, and the reference to his decision in Wood. Now, Lady Lords, you may decide that this is all a bit of a storm in a teacup, because this section of the analysis appears in the appears at the point of the judgment where Judge Johns is addressing the leasehold covenant. And you will have seen that Mr. Justice Meade says, well, he's not using subsequent conduct to construe the planning permission. Friends adopt that approach, and indeed, if you say if you think likewise, then I don't need to address you on it at all. The reason why I have done and made something of it is that Wood is a case about construing planning permissions by reference to the way in which they were implemented in the period after the permission was granted, and it's difficult to see why Judge Johns makes mention of this at all in this context, if it was not providing some support for his views about how to read the planning permission. And he did make a finding at the start of his judgment that, contrary to the impression that one might glean from looking at the plan at 403A, the kitchen facilities were constructed in the southern half, not the northern half. But even I say this is merely supporting or subsidiary material. I've set out in my skeleton argument why I say it's contrary to principles of interpretation. That's at paragraph 38 of my skeleton in page 129. I don't propose to add to that unless your ladyship would like me to. But suffice to say, even if I'm wrong about whether that departs from orthodoxy in terms of construction of planning permissions, it doesn't take one any further anyway, because whether the kitchen facilities are in the southern half or the northern half, it's still capable of being used as an office or partly for an office or some other business in just the same way. So it really doesn't add to the...
Are you saying that it's illegitimate as an aid to interpretation of the lease?
No, because this happened in the intervening period between the planning permission and the lease. It's perfectly open to...
And what's your claim based on?
Well, my case is predicated on the assumption that whatever the planning permission means by live-work unit, that must be what the obligation is in the lease.
Yeah, your claim is under the lease.
Yeah.
It is.
So it's legitimate when we look at the obligations that you're pursuing in your claim to see what the state of the premises is, or was at the start of the lease which you rely on.
Quite, my lord. However, I can't imagine that there is a world in which, when you construe the planning permission granted before the lease, you decide that what it authorises is live and work use. And yet, when you then get the later grant of the lease saying you must use the premises as a live work unit in accordance with the planning permission, the fact that the kitchen facilities were constructed in the southern half would lead you to conclude that the meaning of live work unit in the lease is broader, more generous, different to the meaning that that term carries in the planning permission. And as I stated at the outset, I think it has to be right, and I don't know whether there is any dispute about the fact that really my case stands or falls on the meaning of the planning permission, and whatever the planning permission authorises is whatever the lease requires the tenant to do, or not to do, as the case may be. So I can't see that the lease is going to have a different...
Who fitted out the premises?
Sorry?
Who fitted out this flat, this unit?
I'm not sure that we...
Paragraph 4, it says, as constructed by the original landlord developer, the kitchen was formed, in fact, in the southern half.
So the landlord puts in a planning application without designating separately the workspace and the residential unit. The local authority grants planning permission without any conditions separately designating any part of the unit. The landlord implements the planning permission in a way that doesn't differentiate between workspace and residential unit. The tenant comes in and agrees to pay rent for that unit in the state which they see it, and unbeknownst to the tenant, which bit of the unit, therefore, is supposed to be used for work and which is supposed to be used for accommodation?
Well,
just so I'm clear that if I was that tenant, I'd want to know which bit am I supposed to use on your interpretation for work and which bit for...
Both as a matter of the planning permission and the lease, it is a matter for you, the occupier, because unless and until the local planning authority prescribes, designates that there is one area that can be used for business and one area which can and can only be used for residential purposes, it's up to you. And of course,
or would you, if you were well informed about Southwark's SPG, say, well, since there's no separate designation, it is legitimate for me to use this as for domestic scale activity, because it hasn't been prohibited, and I can use it for single person operations of the type identified there, writing, drawing, all the like.
No, my lord, what I say, the correct reading of the planning permission is that the reasonable reader, armed with the permission and with the SPG, and to some extent the 99 planning permission, would conclude that what is authorised is that the unit be used for live-work purposes. All of it is consistently shaded. That means that it must be used for both business purposes and for residential purposes.
Well, why wouldn't he say that, in common with the vast majority of live-work units in this area in Bermondsey Street, which have been constructed around about the time, the majority are being used for single-person domestic operations. This is just another one of them.
The majority are being used in practice, yes, by people who are not adhering to the spirit or authentic live and work use. That is not what the SPG, I say, is doing.
But if the council wanted to stop that, they had the means to do it and didn't do so.
Well, equally, if the council wanted to grant a permission that is of the kind that I say it did, namely one that leaves it up to the occupier to decide how to divide up the space and what business to do, that is the way in which you would do it. And I say the reasonable reader would conclude that that is much more likely than an interpretation that acknowledges that the local planning authority is effectively giving its blessing to simply using these premises as just a flat, which flies in the face of...
Or just as a flat with drawing, writing, photography.
Lady, you can do that anyway. I mean, part of the complaint is that you can do that anyway under a C3 permission because we've got the decision in Sage, which we can look at in a moment, which says that you are entitled to do a certain amount of business activity even within a C3 permission. It just has to be...
But putting aside the deferral officer's comment, just looking at 3.3.2 and 3.3.4, nowhere does it say this type of domestic scale activity, which is being conducted in the majority of the units in Bermondsey Street, according to this, is unlawful or contrary to planning permission. It just says it's not in the spirit of live work use and should not be encouraged. And it goes, and it further in 3.3.4 says that if you don't define the area, it appears to to allow single person operations to operate legitimately. I mean, you never answered the question what legitimately meant.
Well, what it means by that is to get away with, because we will not successfully be able to enforce against you because...
Well, so in your world, legitimately means doing something illegitimate but getting away with it.
Yes, that is how I say that falls to be read. And 3.3.5 is another provision that contributes to whether the existing live-work planning permissions are permissions which are intended to be capable of being used for just domestic purposes. And the fact that you may be paying council tax and asked to pay council tax might encourage you to think that that's okay, but that is an abuse of the lawful use of an approved live-work unit. That statement could not be there, in my respectful submission, if live-work unit simpliciter, X of any conditioning, was something that meant and which authorised residential use.
I'd read that one the other way. That
dear.
was, you've saved yourself business rates, therefore this is just going to be a working unit, and you're only paying domestic tax. I mean, you may be right, but that's how I'd read that.
Oh, well, I would encourage your lordship to read that differently. I think that's fairly clearly saying small live-work units may be charged council tax because...
And not business rates. And that may encourage abuse of the lawful use of approved live-work units.
Yes.
And
so somebody who gets a bill for council tax says, well, I see, the local authority is treating me as being just a flat by sending me council tax bills rather than rates bills. So being just a flat is okay. And I can carry on. I can dispense with business activities, however large or small, and I can use this as just a flat. And I read that paragraph as suggesting that that is an unfortunate impression if it is gained, but very much, I mean, the language there is much clearer than in 3.3.4. I would accept that much, that is an abuse of lawful use of approved live-work units if you do use it as just a flat. With your ladyship's permission, I will move on to the next component, which is work. Meaning of work, before I get into the rival interpretations, the first thing to say is that the question of what the work component of live work means is one that arises on both learned friends' interpretation of the oblique stroke and my own. It arises in just the same way on her construction, because the oblique stroke means and therefore the unit can be used partly or indeed wholly for business purposes. So you've got to grapple with this issue on either reading of the oblique stroke. And my position is that if one looks at the operative part of the planning permission, on page 96, one sees that planning permission is granted for 13 business units, 14 residential units, and 1 unit, I say, which is a mixture of those two things. Live work, I say, is a snappier way of expressing a mixed residential and business unit. And I say that the reasonable reader would give work its ordinary and natural meaning as connoting business or commercial activities designed to make money. It's my case that a compliant occupier of Unit 8 Bickle's Yard must be carrying on activities such that if the man on the Clapham Omnibus were to ask, "Where do you live?" he would answer 8 Bickle's Yard. And if he were to follow up with the question, "Where do you work?" he would receive the same answer. In other words, a live-work unit is a place where rather obviously one both resides and makes one's money. It's their home and their place of work. It's for that reason that I say live-work use does not extend to permit an occupier to carry on business somewhere else and merely bring home work in the evenings and on weekends, as we of course all do. And it does not extend to activities such as voluntary or charity work, personal study, pursuit of hobbies or interests, or any other activity which is not commercial, not designed to generate income. And I say that the notion of business use is a recognisable one. As we've just seen, it occurs within the planning permission itself, where permission is granted for business units, not limited to B1, of course. We've seen already some of them were the antiques showroom, A1, B8. So that phrase is familiar within the planning permission itself. It's also familiar in the SAGE decision that I referred to in just a moment ago. Perhaps if I could invite your ladyship and your lordship to...
Just before we go back, can I just sort of clarify what you say is and is not work? So if you, Mr. Duckworth, are doing remote hearings from your work-live space, as many case management hearings are now,
Mm-hmm.
or if you are a general practitioner and you're sitting at home in your work space doing consultations on the telephone or through Teams or Zoom, you would say that is not work.
I would say that that is work in the sense that it is not voluntary, non-commercial activity, but that is not in compliance with the requirement of the planning permission, because my place of work, my main place of work, is my chambers, and in reality what I'm doing in those instances is doing a hearing from home or a call from home for convenience purposes, but it wouldn't be right for me to answer to the man on the Clapham Omnibus, where do I work, to answer 20 Lawn Crescent in Kew. The correct answer is I work in chambers, but I do occasionally do conferences and...
What happened?
If you're a civil servant, and we know that a lot of civil servants now, there isn't the desk room, and so they are required to work at home 3 days a week and only come in 2 days a week. So they're not working. They're not working because the Ministry of Justice, where there won't be a seat for them, is their place of work.
Well, lady, I do accept that there will be hard cases when one defines the parameters of work, but I would suggest that the solution to your ladyship's problem is to ask, where do they work? Where is their main place of work? And if the answer is somewhere else, then that's no good. If one gets to the point where genuinely the individual in question's place of work is the live work unit, then that is compliance. And your ladyship and your lordship are interrogating me about that in terms of my my construction of work, but of course that arises in exactly the same way on the learned friend's construction.
I hope not interrogating, testing.
Yes. Delicately arm wrestling me on the question, but I do accept, I have to be frank, that the question of work is not without its difficulties and that there would be difficult cases in which it would be difficult to, the local authority would have to think long and hard as to whether that would be compliance. But there's nothing strange or unusual about that, and indeed in the Sage decision that I was going to invite your ladyship and your lordship to take a look at now, one can see just this sort of problem arising in another context. Page 233 of the authorities bundle. This is the decision in Sage. Secretary of State for Housing and Local Authority. And 233 at paragraph 81. As you will see partway down the paragraph, that what this is all about is the extent to which business use in a dwelling house may be permitted under a C3 permission. And first of all, I would invite your ladyship and your lordship to note that the concept of business use is being applied there, which is, I say, a familiar concept in the planning arena. What it indicates is that under a C3 permission, you can undertake a certain amount of business activities within a C3 permitted property without exceeding the limits of your planning permission, provided that it is such that it remains ancillary or incidental, then that is okay. There is no material change of use, no breach of planning control if you don't apply for planning permission. And of course, at the limits of that, there is no handy statutory definition as to what is ancillary or incidental. There is no policy or guidance that says that once you exceed X number of hours a day, Y number of days a week, or indeed occupy Z percentage of your home for business purposes, that you exceed that limit. That is, if you like, that's simply a matter of fact and degree, and it's something that the local authority and the owners in question have to deal with, a bridge that they have to cross when they get to it. But there is nothing strange or unusual in my respectful submission of there being difficulties of application of this kind in the planning context, and as I say, business is a well-recognised formulation both within the four corners of the planning permission and as a matter of the general law.
So you're saying when it says live work, the work component must comprise a business?
Yes, it's business activity.
So why didn't they say live business?
Well, in my submission, if you read the supplementary planning guidance.
No, but if they mean business, why don't they say business?
Well, they plainly have used the term work for, if you take the standard form of, if you take the ordinary live work unit planning permissions, work is plainly a cipher for business. That is what it means in 99 out of 100.
But in the planning permission, it differentiates them. It has, this is the business, these are the units for business, these are the units resi only, this is the one for work live.
Well,
and also, if you don't follow the guidance that you've taken us to, with your square footage and your lists and your this, that, and the other, you're immediately putting them in considerable difficulties in running what you would define as a business for employees and all the rest of it.
I'm so sorry, milady. Say that last bit again.
But well, in any event, if it has to be a business, all the more reason the guidance saying the right square meterage and lifts and bulky items access and all the rest of it to be enforced.
Well, I agree that the fact that live work means, as is stated in paragraph 1.2 of the SPG, living and working accommodation, and that equates to business use, is one reason why, generally speaking, planning permissions include those conditions. But let's put it the other way. As I say, this is not a difficulty that besets my interpretation alone. And what is the alternative? The judges below said, well, that business is too narrow. It's something wider. Well, in that case, one asks rhetorically, well, what is the wider concept of business? Neither of the judges, nor indeed my learned friends, have attempted to lay down the parameters of the wider concept of business. They have not stuck their heads above the parapet in the same way that I have done. And it's rather difficult to take shots at their alternative reading as a result. But let us be clear, it must be capable on the alternative wider concept of work to decide what that is so that the local planning authority can say, in an appropriate case, you are not carrying out work within the scope of your live-work planning permission, so that the court can do that. And it must be possible, if the reasonable reader of the planning permission is going to reject what I say is the meaning of the term work, or what it's to be equated with, it must be possible for him or her to say what the wider concept of work is. And nobody so far has come up with an alternative and attempted to define what work means if it isn't business designed to make money. And one can understand the reticence because, well, where does one draw the limit? At what point does one come outside work? Does it include charitable endeavours, voluntary work, hobbies, study? Is work simply being contrasted with leisure, anything that isn't feet up in front of the television or with a book in your hand? The alternatives, I say, I entirely accept that it is possible to take aim at my reading of work and that there are criticisms that could be levelled at it, but I do say that there is no alternative formulation that anyone has been able to put forward, and it's difficult to see how they could put forward one. So even if I am the lesser of the various evils, I do suggest that my definition of work is workable, recognisable, and that there is no rival reading of the term work that could usurp it. So for that reason, I commend it to you, and I have been through the SPG, which contains numerous references to setting up of businesses, encouraging employment, all of the provisions in 3.3.5, including mortgages being included in the business category. That all the flavour of that document is all consistent with my reading. The planning officer's report, I'm not commending that to you as a document that is publicly available and that you ought to be bringing to bear in your construction. But if I'm wrong about that, it is noticeable that the planning officer also referred to genuine live-work business unit. So in the absence of any alternative concept of work, I commend mine to the court. I should briefly say something about the...
Just out of interest, where does the expression live work come from?
The Americans. My lord, the concept of live work is something that we borrowed from the Americans it became very fashionable in places like New York, and it was imported in the early 90s into certain London boroughs. I believe the London Borough of Hackney was the first to champion it. But
Shoreditch was all developed as live work. I mean, it was all the old warehouses.
Yes, exactly. It was a way of bringing back all of those old premises.
Yeah.
And in America, there was the same phenomenon with trendier, more versatile forms of business like photographers and so on.
No, we're not allowed photographers.
Sorry.
We're not allowed photographers.
Well, I'm talking about in the US, lady, but that's where it came from.
And when we imported this concept from across the Atlantic, was any thought given to calling it anything different? So as to introduce the precision that you now suggest we ought to.
I am not aware. My knowledge.
Make it live business.
Well, yes, it's just that it would be much better, I agree, if live/work had instead been described as mixed commercial and residential units. It just doesn't trip off the tongue, I think, is what it comes down to. My knowledge comes from reading the 2006 report.
But you nevertheless want to penalise or either sue or potentially criminalise people for misuse, abuse of this rather vague concept.
Yes, but that there is a tendency to regard my interpretation as being the one to which that criticism applies. If it's live and or work, then these premises, Unit 8, could be used just for work, and or partly work and partly residential purposes. So you've got to grasp the nettle, and as difficult as it may be, you and the reasonable reader need to decide what work means, to give it a meaning. And it would apply, and the risk of criminal sanctions eventually would apply on the and/or reading. The occupier of Unit 8 might have wished to carry on simply a small office business, a travel agency or an insurance broker, as the last people did. And therefore, you've got to decide what work is, and if and to the extent that the person who is using this unit is not doing whatever work means, then they are potentially subject to criminal sanctions in exactly the same way. So I do urge your lordship to keep in mind that this problem besets all three interpretations of the oblique stroke. And in relation to criminal sanctions, one has to see that to some extent in context. If you act out inconsistently with your planning permission, you don't commit an offence. You run the risk that you will get a letter from the local authority, and eventually, if you don't change your ways, you may have an enforcement notice. And at the end of that period, they have to give you a certain amount of time in which to scale back your activities or scale them up, depending on what it is, or you can appeal it. And at the end of that, I accept that if you are still using your property in excess of planning permission, you could commit an offence. But that is a risk that the occupier of Unit 8 will run, whether they decide to use it for residential for live and work purposes or purely work purposes. And that is a problem that spans both of the interpretations that are being promoted today. May I say one thing, unless your lordship or ladyship have any other points on that? The other aspect that I need to briefly deal with is the suggestion in Judge Johns's judgment that even if I'm right about the oblique stroke and right about work, anything more than negligible work will do. It's not entirely clear where that notion has come from, but once it is accepted that work means carrying on a business from the premises, then that activity must be carried out consistently. There is no justification for applying some different test, the anything more than negligible test. I, of course, don't say that you have to carry on work 24 hours a day, 7 days a week, 365 days a year. Normal and natural intervals that any business, your business, would have, of course, will not break the thread of continuity, but merely occasional or intermittent business use is not going to satisfy the requirement under the Live Work Planning Permission, as I say you should construe it. May I move on to breach? I will deal with quickly. Assuming I'm right about the meaning of the oblique stroke, you will need to go on to consider whether the activities carried on by the respondents constitute compliance or breach. That is not a matter that Judge Johns formally determined, because he agreed with my learned friend about the meaning of the oblique stroke. But he did make certain findings of fact, which your ladyship and your lordship will find in the core bundle at 259. Between paragraphs 10 to 12. There are two things going on in those paragraphs, as I see it. There are findings of fact as to which particular activities were carried on, and to be clear, I do not make any challenge to those findings of fact. And then there is an evaluation as to whether those activities constitute work or not. And logically, bearing in mind the conclusion that Judge Johns comes to in paragraph 37, the test that he is applying is his wider concept of work, rather than my concept of work being equated with business. And I do say that Judge Johns has applied the wrong test, and having misconstrued work, his evaluation about whether the activities, particularly post-2014, are work, cannot therefore stand. I do say that you have sufficient material before you to substitute your own determination of that matter. That is because you have the benefit of Judge Johns' findings of fact as to what took place at the unit, and because you have the evidence in the witness statements and the transcripts that I will take you to in a moment that enable you to make a determination as to whether or not those activities satisfy work properly construed, as I say it should be construed. There are two distinct periods that you need to look at, one of them more straightforward than the other. The period 2009 to 2014 is easy because, as Judge Johns found in paragraph 10, during this period, the first respondent was a medical student and then finishing his training in hospital rotations. Second respondent was a solicitor working for Lovells at their offices, and as he found, little work was done during that period. And Mr. Justice Meade said that he would have found that the activities found by Judge Johns during the period 2009 to 2014 would not have constituted compliance with the work requirement, even applying the broader concept of work that was favoured by both Judge Johns and by His Honour Judge, by Mr. Justice Meade. There's no challenge to that aspect of Mr. Justice Meade's decision, and it must follow that if I'm right about the meaning of the oblique stroke, whether or not I'm right about work being business, not something more than that, I'm entitled to my determination that there has been a breach of the covenant in the lease reflecting the planning permission for the period 2009 to 2014. So I'm going to focus my fire primarily in the time that remains on the later period.
Can I just ask you, before you leave that bit, that would still be covered by the £5,000 negotiation damages?
Yes.
Yeah. So it's just the extra declaration, as it were?
Yes, I'd be entitled to a determination that there has been a breach, and then there would need to be damages apportioned to that period. If you did not also side with me on the 2014 to the 2019 period. In relation to 2014 to 2019, I accept that I can only win in relation to this period if my reading of work is right and the judges below are wrong about work being a wider concept. But if we take the respondents in order, in relation to the first respondent, the activities that he says he undertook at this during this period are set out in paragraph 120 of his witness statement.
Well, just before we go there, I'm not sure why we're going to the witness statement when we've got the findings of fact of what they've done, and you say you're not going behind them. I really don't understand what the relevance is.
Well, let me endeavour to persuade your ladyship. I do not go behind the findings of fact as to what that His Honour Judge Johns made as to what the parties did at the unit. It is not what I'm looking at, but what His Honour Judge Johns did not engage with is whether those activities constitute work as I say that term should be construed, i.e. business. He didn't need to, because his view was that work is not to be equated with business, so he was applying a different standard when deciding whether those activities constituted work. He was not applying his mind to the question of whether those activities were business, as I say.
Have you spoken between you? Is it said that they would amount to your bright line definition of business?
No, it's entirely unclear. Our position is that if an evaluation needs to be carried out on the basis of a different test, then the matter has to be remitted. Equally, our position is it would have been open to the appellant to have explored this below, cross-examined the witnesses on that basis for the purpose of extracting more amplified findings, but none of that was done.
It was done in the sense that one of the things that I'm proposing to take you to is the cross-examination in which both respondents gave their answers about whether those activities were gratuitous or whether they were paid work. And they did give answers, and His Honour Judge Jones didn't make findings about that, but that is a natural consequence of his determination that that factual issue doesn't arise because work doesn't mean business. It includes charity work, voluntary work, and all the rest of it. And so he has not made any findings, but that is because that was not his decision on the meaning of work. But I say it's open to you, having the benefit of the transcript to see the answers that they gave and the witness statements, the witness evidence that they gave, to apply the correct test to Judge Johns's findings about what activities were carried on and to make that determination. If you're against me as to whether you have the capability of resolving whether the activities are business, work in the business sense, then my learned friend would be correct that you'd have to remit that to Judge Johns to determine. But given that you have a transcript in which they give answers, clear answers as to which of those...
How long are you wanting to spend on this, and in what depth are you going to want to
well,
your way through the
I suppose
statements and the
it
transcripts?
would take me about 10 minutes, I would think, possibly a fraction more.
Let's get it done before the short adjournment then, and we'll decide what we do with it in due course.
Very good. The activities carried on by the first respondent are set out in paragraph 120 of his witness statement, which you will find at 107 of the unagreed bundle. And of those, the only activity that is work, that is paid work, part of his job, is paragraph A, which is as part of his NHS GP practice, triaging and consulting patients by phone and completing the paperwork at home. If you look at his oral evidence, which you will find starting at page 111, you will see that in internal page 5, a line of cross-examination took place to establish the first respondent's career path. But where that ultimately ends up, just to short-circuit this to some extent, is on internal page 12.
Don't we look at number 8 as well?
Yes. Yes, that's right. Sorry, that's a false reference. Where that gets to is that the GP practice started in June 2019, which is, as your ladyship kindly points out, at the top of page 8. That's a month before proceedings are issued. It's right to say, and the reason I was taking you to 12, is that he went on to suggest that some of his the articles that he wrote were paid work, but as he accepts there, and going on to 13, bottom of 13 and top of 14, he candidly accepts that that is not, in any sense, carrying on a business, and that he's in effect talking about taking work home. If we move on to the second respondent, in paragraph 11 of Judge Johns' judgment, he identifies effectively 2 tranches of work. The first is all of the international advisory work that is listed in paragraph 11. And secondly, from and after 2015-2016, it's work as a barrister. And ultimately, if one looks at the cross-examination in the unagreed bundle starting at page 116, we can see that the international work turned out to be voluntary work, and one can see at 116, bottom of page 63, and you refer to the international work. At 65 and 66, Judge Johns starts to ask a line of questions about that issue and the extent to which the clerks, that work is brought through chambers and clerked and treated in the same way. But that ultimately, as you see from page 66, line 20, and again in line 1 of 67, it was accepted that this international work is voluntary work. So it's not business work at all. As far as barristers' work is concerned...
But why wouldn't acting pro bono in litigation be business?
Well, providing advisory work, if I'm right that business connotes money-making, income
money
generation.
only.
Yes.
So acting pro bono, even though it may be doing good, but you might also be developing your practice. You might be discharging your regulatory requirements. That's not business.
Yes, that's right.
That's your analysis.
My submission is that work is not, one is not looking at doing good. One is looking at the activities that are income generating, and there's not going to be time now, but I've given you.
But what about the marketing aspect? Suppose I'm really cynical, and actually I don't care about the people I'm helping with, but actually it's making me look better and increasing my practice. Are we to have an inquiry into each bit of pro bono work?
Well, I agree that would be a harder question, because marketing as an activity intended to supplement your work stream and your income would be much more likely, I think, to be properly regarded as work. But it's not how it's portrayed or characterized.
No, I'm not
by the
suggesting for a moment,
respondent.
but if your test must be capable of withstanding these sort of
Yes,
difficulties.
I agree. But it's how it's characterised as voluntary work, and indeed he goes on to explain that they both have a strong sense of wishing to give back to the community. This is not being suggested that this is marketing to ensure that an increase in paid work.
Attention please. Attention please. This is the incident control officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
If I may continue normal business
Yes.
for 2.5 more minutes.
Can I just?
Attention please. Attention
You
please.
continue normal.
This is the incident control officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Milady, I think you had a question for me. Or
Just skim reading the transcripts here. It does seem that it's real mix and match, as Lord Justice Dingemans says, because the Guardian, you get paid by the word. Some after dinner speeches you get paid, and and some you don't. It's just fun to do. If you're working for St Vincent, then you get a lower fee. But if you're working for other people, it's pro bono. But you're saying you just have to strip out that which is directly paid for, and that counts as business, and otherwise it isn't. And what would you have to do? You'd have to show the large proportion of it is business before you are not in breach of your lease?
I do say you certainly have to strip out voluntary activities. Doing good and personal study.
But marketing doesn't do.
Marketing, I agree with my lord's point about that marketing might well be work, because that is intended to promote your practice, increase the work coming in, and ultimately generate income. So I would accept that if it had been the evidence that these were marketing activities rather than giving back to the community, charity work, that might be a more complicated question. But we're not in that territory.
What about a quiet room in which I wish to write my novel?
If that is, assuming that is recreational.
No, I want to write a novel.
Well, yes, I think that would be recreational, unless you're saying your lordship is a writer, and that is your job, and that's your place of business.
I might quite like to publish a novel if other people think it's publishable, but I'd like to sit in a quiet room, away from all the hurly-burly of the domesticity, and write a novel.
Well, that would be a matter that would have to be tested on.
Where does it fall on your test?
Well, I say that...
Bearing in mind that one of the respondents has done just that.
I don't accept that this respondent suggesting that he's writing a book is satisfying the business, the work component of the live-work requirement. I come back to where I started, which is that...
But if he sits down and decides he'd like to write a book, which, if it's good enough, might ultimately be published for profit, why isn't that?
If he gives up his seat in chambers and decides to become a writer and comes to the unit to do his writing, which is how he's going to earn his crust, then I agree, we're in changed circumstances.
Why does he have to give up being a barrister?
Well, because my starting point for all of this is that the reasonable reader would assume that effectively the answer that you give to where do you live and where do you work is Unit 8 if you're complying with the planning requirement. So if he has given up his seat in chambers so that this is his place of work, then that's one thing. But if it's incidental, moonlighting, then that wouldn't be it. And as I say, this is a problem that I accept that there will be factually difficult scenarios, but it would arise on.
Yes, but you're what I'm trying to do, I think, is you are putting in front of us what you say is a perfectly formed, bright line test, which is easy to apply.
Well,
and it's business, which you say has an accepted meaning, which seems to be something involving doing something with a view to profit, I think.
My lord, I don't say it's easy to apply. I say this is the best that we have, and nobody else has attempted to do what I'm doing and formulate some form of parameters within which the decision about whether something is or isn't work is to be undertaken.
The argument against you is that if you wish to impose legally binding permissions, the consequence of breach of which could be significant upon somebody, you have a duty to do it precisely, and if you don't, then they're not in breach.
Well, let's look at it from the alternative. If my learned friend is right, this is live and or work, your lordship ought to be putting to her, well, if you're saying that this is...
I haven't had a chance yet, so...
No, I appreciate it. Well, I'm hoping to charge your lordship's gun. And you ought to be... She has also got to say, well, this is what I say work means, and also it's reasonably clear and reasonably easy to understand, and there's going to be enormous sport to be had for the taking aim at whatever that alternative concept of work is, because of course there's going to be points to be taken about, well, what would you say on this set of facts, whatever the weather. But I'm the only one so far who has ventured to put forward some form of workable definition of work that could be applied, and you have to make some form of decision about that. Well, the authorities are reasonably clear, certainly in the conveyance arena, that you have to have a decisive result. You have to decide, for better or worse, what this means, and your lordship would be in a position to attack my learned friend's definition of work when she lets you know what it is.
Where have we got to?
I've dealt with international work being voluntary. All you need to look at in terms of the barrister work within this jurisdiction is top of page 60.
Well, I don't. Sorry. Yeah. Well, if you've not finished that, it's 5 past now.
It's 30 seconds, my lady. It might be neater if I just invite you.
I think my lord has a meeting, so if you just give us the page reference.
Well, if you would just read 60 to 62, you will see the sequence of events in terms of when he ceased to be a pupil.
How much longer?
That's really all that I've got to cover with you.
Excellent. Well, thank you very much. I'm sorry we can't finish off, but we need to adjourn. Should we say 2:05? Thank you very much indeed.
All right.